It's okay.
Your Honor, I'm asked for 112 on Mr. Merritt. There's a motion to suppress that's in the works. All right, so I'm working on a motion on your case. We're at 112 in the court date.
All right, well, I'd like to make sure my bond was revoked on this.
Okay, I'll look into it. All right,
Okay.
all right, bud. We can't address bond today.
Okay. Am I good?
Yeah, you're good.
Next is Raul Miller.
Your Honor, we have Mr. Raul Mia on 4 cases, 23 CF 1501, 23 CF 2492, 23 CF 2493, and 23 CF 2513. Your Honor, at this time, I'd like to set these for plea or trial.
All right, state,
We are ready for trial.
which case we trying?
Well, Your Honor, I do not have the case number.
I do.
Is it 1501? 1501? Is that 23?
23.
Yeah? Okay, perfect.
And if we try the case, how many days?
I think that's probably going to be a 2-day independent jury selection.
You agree, Mr. Cochran?
Yes, Your Honor.
And how many jurors do you think we need considering the nature of the charges here?
I would say potentially 50.
I think that'll work.
All right, and is the state's offer still what was announced on 9/10?
That is the 2024 Department of Corrections offer, yes, sir.
All right. And the maximum exposure is life in this case, right?
Yes, Your Honor.
All right. All right, we'll see you on docket day.
Your Honor, if I may speak on the record.
We'll talk to your lawyer first. Does your lawyer know what you're going to talk about?
Look, my attorney was given a chance
I
to come and bring me what I've demanded from him on the Nelson hearing of October 23rd, but he hasn't brought me everything that I need or what I've demanded from him. And we're already at the stage where we're talking about trial, but there is no defense ready that he's even gone over with me. So I don't think he has the best interest in me, and I'd rather him get off my case or withdraw from my case and appoint some other counsel who's willing to help me, because he hasn't brought me, I could show you all the list of reasons. He hasn't brought me everything that I need to see in order to prepare a defense. I've asked him to bring me copies of the medical release reports of the injuries sustained from the victim. He hasn't brought me that. I haven't seen all of the body cam footage of the interviews and follow-ups of the victim. Haven't seen any of the surveillance videos that allegedly captured the alleged incident, and I haven't seen that. So I asked my attorney, I demanded that he file a motion for a bond reduction, which he's never done, hasn't done it still. I've asked him to gather expert witnesses, and he hasn't gathered anything. Plus, I just realized that none of my attorneys on any of my cases ever disposed any of the medical personnel who were involved in treating the victim's injuries. So, and I have more on the other cases, but this is just regarding the case that's talking about going to trial. And I just don't think I don't think he has the best interest. And I just don't think he's a trial attorney.
Mr. Cochran, you have anything you wish the court to consider?
Your Honor, I did go see my client last week. The video I brought is not the video that he wanted to see. And he did give me a list of a couple other things that he wanted to be brought up there. I've been in court this week, I haven't had a chance to get it up there. I plan on going up there by Friday, and I'll take the other documents that he listed that he wanted to see, I'll take up there with me.
Okay. Well, I can't make the finding required to discharge your lawyer based upon what you've told me.
Your Honor, if I may, this is why I had the Nelson hearing, because he hasn't brought me anything. He brought me one video, which is of no use or value to my defense. So when is he going to bring this? Is he going to whip up some type of defense by trial? I don't think so. And it just got to the stage where how long am I going to wait to actually get a defense ready?
Yes, sir. And once again, I can't make the finding necessary to discharge him, so we'll leave this set for docket day.
When
And
is
your
the docket
lawyer will
day?
talk to
Monday,
you.
11/17. I'll talk to you, it'll probably be Friday. I'll bring you those other things.
Have the Amaldo.
Your Honor, on Mr. Mobley, I'm going to ask for 112. I've deposed witnesses. The victim did not make the deposition. There was a confusion about the time, so I do need to reschedule her. But the depos took place on October 20th, so it's in the process of getting done.
State?
No objection.
All right, it's 112.
What about speedy trial?
Well, I gotta get proposed to witness before I file a demand. All right? Once I depose her, then we can talk about speedy. All right?
Right. Does she need to be drug tested?
That's not something I can do.
It's be William Moore.
I ain't even got his plea form here yet. How's it going? Your Honor, Mr. Moore is going to be a plea. Unfortunately, his paperwork's still sitting on the printer downstairs. Oh, actually you did? Yep. Awesome. If I have one moment, this
Yes,
is
sir.
the offer we just. At this time, Your Honor, my client would like to enter a plea. In exchange for a plea of no contest, the state has agreed to a withhold of adjudication, 2 years probation, no trespass at Elder Care Services of Fort Walton Beach, cost of prosecution and cost of defense. I have a signed plea form and a score sheet if I may approach.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. Cochran said. You signed the written plea form.
Yes, sir.
How old are you?
Me, I'm 40, sir.
How much education do you have?
I graduated, sir.
All right, you able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And it's what you read in the form, what Mr. Cochran just announced to me.
Yes, sir.
Do you understand you're pleading no contest to the announced charge?
Yes, sir.
And that tells me you believe the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that.
Yes, sir.
Do you understand by doing this, you're waiving your right to that trial by jury where the state would have to present that evidence to convince them of your guilt?
Yes, sir.
All right, in this case, adjudication will be withheld. You're going to be on 2 years of probation. You can't go back to that place, and you got some fees and costs you got to pay in addition to the standard terms and conditions. What are those fees and costs, Madam Clerk?
$550 court costs, $150 public defender fee.
Okay. Mr. Cochran answered all the questions about the plea and how it affects you.
Yes, sir.
Satisfied with how he's represented you.
Yes, sir, very much.
Court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Yes, sir. Thank you, sir.
You're welcome.
Next will be Riskish Mosley.
I'm setting you for clear trial, because you have court again on Monday. I'll talk to you on Friday. I'm setting you for plea or trial. Your Honor, we have Mr. Rakesh Mosley, 23 CF 2386. I'd like to set this for Monday, plea or trial. Right.
So this is, and I'm just checking the, did you get the depot of the FDLE done?
No, Your Honor, we did do a motion to suppress, and that was ultimately denied. I think that negates the need for the FDLE.
All right, and so my notes were the last offer the state have was 7 years Department of Corrections as a minimum man, fees and costs, the $50,000 fine and surcharge. And is that the state still offer?
Yes, Your Honor.
All right, and what is the guidelines?
The guidelines, I think, will come out probably around 60 months with a maximum exposure of 45 years.
Yeah, the score line is 46.8.
But the minimum, 46.8 months or points?
That's months.
But the man takes
The man
precedence.
is 7 years, yes, Your
Okay.
Honor.
And so essentially, the state's offering the low end of the sentence, correct?
Yes, Your Honor.
And that's with no probation to follow, right?
Yes, Your Honor.
Okay. And does that offer remain open till docket day?
Yes, sir. And at that time, if it's not accepted, it will be withdrawn.
Okay, and so we try the case, how long to try the case?
I think 1 day independent of jury selection.
You agree, Mr. Cochran?
I do, Your Honor.
And how many jurors?
Standard number.
I would say because it's criminal, I would request 30.
All right, so we'll leave it on docket day, plea or trial, and we expect 1 day with 30 jurors, and the offer will be revoked if it's not taken on docket day, and your client understands that after docket day, absent extraordinary circumstances, the court will accept no plea other than guilty as charged after docket day. Mr. Cochran, you talked to him about that?
I have not fully talked to him about that, but the court, I think, has laid that out.
All right. All right, we'll see you on docket day. Thank you.
Next one would be Jamie Munoz.
Is your case number, please? Case number.
Yes, Your Honor, this is 25 CF 1424. Your Honor, as far as the next court date, or next pretrial, I would ask for the January 12th. Mr. Munoz, the pretrial was scheduled, but he was out of Iowa on parole. I've spoken to his parole officer. He can go forward with a bond hearing, or I guess at this point, the state's pretrial detention hearing, if the court has a date after Mr. Gomez is back.
All right, so we'll set that. What are we looking like next week, Madam Clerk?
Twentieth. 46 cases in the morning and 3 in the afternoon.
All right, we'll set it on the 20th for pretrial detention.
You have a 2:30 docket that day as well.
Yeah, we'll set, since we're talking about pretrial detention hearing, correct?
Yes, Your Honor.
Okay, we'll set the PTD at 12:30 on the 20th. And we'll reset the case, we'll talk about resetting the case after that.
Yes, Your Honor. Thank you.
Newman?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I've got this. Let's roll. Fight fire with fire. Take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire.
Damn thing ain't working. Whoa. Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right, 25 CF 0982. Your Honor, I'm going to ask to set it for, leave it set for 11:20 for the bond hearing, and for the pretrial, we'll ask for the 112.
All right. All right, we'll remain set for the bond hearing on 11:20, and we'll, when the state gets their response, we'll reset the motion to dismiss, and we'll then continue the full case to 112 and see where we are then.
Yes, Your Honor. And
Okay.
as soon as I get a response, we'll file the notice of hearing.
Very good. Take the motion to dismiss off for the 20th at this time, Madam Clerk.
Yes, Your
Okay?
Honor.
All right, thank you.
All right, buddy. All right. See you Thursday, next Thursday.
Thank you.
One moment, Your Honor.
Yes.
This time I'd like to set this for plea or continue on 11/17. I believe it will resolve.
All right. POC on 11/17. Is there a current offer?
My understanding is it's guidelines, 15.3 months Department of Corrections for both the case and the violation of probation.
We had, Mr. Gomez and I had previously discussed a non-DOC offer, and I want to speak to him again about that, which is why I'm setting for the 17th.
All right, we'll set it on the 17th to give you a chance to catch up with Mr. Gomez to see what the final deal is, okay?
All right.
All right, thank you.
See you Monday. Okay. Okay. That's the offer we discussed before. Okay? All right.
Thank you. Good day, sir.
This is Christian Knopfinger.
All right, Your Honor, we have Mr. Christian Knopfinger, 25 CF 1897. I'm going to ask for 112. There is a motion to suppress that is being worked on right now.
State?
No objection.
All right, continue to 112.
All right. I'm sorry. Okay, I'll come talk to you. Mm-hmm.
This is Eduardo Ojeda.
Your Honor, Mr. Ojeda is going to be a plea. In exchange for, and this is going to be, he should have a second VOP case that was following along. I don't see it on here, though.
I have 25-660 and 24-1312. Is there another case?
No, Your Honor, both of those. I just didn't see on my docket, it only has the 25 case. He's going to enter a plea to both. On the 24 CF 1312, client will admit this violation or will terminate and revoke 1129 Okaloosa County Jail with all credit for all time served. Prosecution, cost prosecution, cost of defense. And then 250660, count 1 will be dismissed. Count 2 would be to adjudicate 1129 with credit for time served. Cost prosecution, cost of defense. Count 3 is dismissed. Count 4 is adjudicate 1129 Okaloosa County Jail. And there's $450 to James Smith in restitution. And there'll be no contact with the victims, Ashley Calhoun, child with the initials CB, or Mr. James Smith. I have a signed plea form and a score sheet, Your Honor, if I may approach.
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you can put your hand down. You heard what Mr. Cochran said and you signed the written plea form?
Yes, sir.
How old are you?
45.
How much education do you have?
My associates?
You able to read and understand the plea form?
Yes,
And did you do that before you signed it?
I did.
And it's what you read in the form what Mr. Cochran just announced.
Yes.
Now, you got two things going on today. You've got your VOP and your new case. We're taking care of them together, but they're different things, correct?
Yes, sir.
As to your VOP, do you understand your pleading, your admission to the VOP?
Yes, Your Honor.
And that says to me, Judge, I violated just the way the affidavit report says it did.
Correct.
And do you understand by making that plea that you're waiving your right to a hearing where the state would have to prove your violation?
Yes, sir.
As to your new charges, do you understand you're pleading no contest?
Yes, sir.
And that tells me you believe the state has the evidence necessary to convince the jury of your guilt, and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to produce that evidence and convince the jury of your guilt?
Yes, Your Honor.
And in this case, as to your, and to both situations, you'll be adjudicated guilty if you weren't previously. Your probation will be revoked and terminated. You'll have the fees and costs, which would be $100 cost of prosecution, $100 state-provided legal assistance, and the VOP. And in the new case, what would be the proper fees and costs, Madam Clerk?
$867.
$867 plus $150 state-provided legal assistance.
Yes, Your
And no contact with the victim, and then $450 restitution to the named victim, and you'll serve 11 months, 29 days in the county jail with credit for all time served. Now, how much time do you need after you get out to get all those things paid?
About 6 months.
Okay. All right. Mr. Cochran answered all your questions about the plea and how it affects you?
Yes.
Satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you. Step.
I appreciate it.
I think, just, can you step this way for your prints, please?
O'Mara, Trenton O'Mara.
Yes, Your Honor. Mr. O'Mara had asked for the 112 court date.
All right. Is there still no offer in the case?
It would be for an open plea. The state's not going to make an offer in this case.
And you want a full continuous, is that right?
Yes, Your Honor.
What is the defendant's score?
I know on my case alone, he scores 23.4 months.
And I believe on ours, it's approximately 12 and a half with the death points.
All right.
Yep, just the
It'll
112.
be
Your Honor.
continued.
Thank you.
Yes, you call it Corso? O-U-R-S-O.
All right, Your Honor, I'm asked to continue this again, 112. I'm still waiting on a report. I'm gonna reach out to them and see what's going on. We requested the eval back in July. From my understanding, the evals have taken place. I just don't have any,
Who did the evaluation?
Dr. McDonald.
Okay. State?
No objection.
All right, it'll be continued, and if you need any assistance there, let me know, okay?
Okay. Yes, Your Honor. All right, I'm still waiting. All right, so we're second for 112. All right. All right, Ben.
This will be Robert Mathias, M-A-T-H-I-A-S.
Hey, I didn't have you on my roster. You want to do that 14-7? at, plea or continue on Monday.
All right, plea or continue on docket day.
All right.
Next we have Talbot, Joseph Talbot, T-A-L-B-O-T.
Mr. Joseph Talbot before the court in 25 CF 1067, Jason McKinney on his behalf. I was letting Mr. Talbot know that the state is not going to agree to Phoenix House at this juncture. He is approved for Phoenix House, but I don't believe the state is in a position to agree to that. There are 4 outstanding depositions that need to be completed in Mr. Talbot's case. That had been put on hold while we were trying to get treatment lined up. That's going to be 2 lay witnesses and 2 law enforcement witnesses. I'm going to seek to complete those depositions as quickly as possible, but that would necessitate a continuance until the January 12th court date. Mr. Talbot has asked me to ask the court for permission for a bond hearing, which is something I can file and schedule with Your Honor.
Get it filed and we'll set it as soon as we can.
Yes, Your Honor. I believe Your Honor has 11:20. I'm not asking for that to be set today, but if I get that set promptly, then we might have some time next week.
Yes, sir.
Okay, if I may address the court about something.
What you gonna talk about?
Just to let the judge know about the situation my family in.
Let's do that at a bond hearing. I got no problem with that. Let's do it the right way. Yes, sir. All right. Okay. Thank you, Judge.
Good afternoon. I'm Gene Mitchell for Gregory Simon. You might recall Mr. Simon is in federal custody.
Yes. Is he still there?
Sure. He's over in San Jose County, but his federal case is proceeding.
All right, so what do we want to do today?
Well, I met with Ms. Shea this morning, and we talked about whether we needed to come over here and stuff. I sent a letter over while I was meeting with her. I think that probably the prudent thing to do is just to, maybe issue a capias so that when the federal prosecution is finished, he gets brought back in front of you.
State?
Obviously, Your Honor, that's fine with the state.
All right, issue a no bond capias, please. Thank you, Mr. Mitchell. Good day.
Next we have Linda Taxter, T-A-X-T-E-R. Taxter.
Jason McKinney on behalf of Linda Taxter. She is present before the court in 25 CF 906. The alleged victim is present in the courtroom here in support of Ms. Taxter. I'd like to come back on docket day, plea or continue. She is meeting with Ridgeway Apartments, I believe, tomorrow, and we should have an answer on potential residential placement or housing by the time we come back on Monday. We are in negotiations with the state. We anticipate that we are going to be in a position to reach an agreement when we come to court on Monday.
And is the state in agreement with this approach to the disposition of this case with the support of the alleged victim?
So far, I'm supposed to get information on Friday, so hopefully that will be satisfactory.
The alleged victim is going to be meeting with Mr. Snell at his office on Friday.
Okay, all right, very good. We'll set it then for Monday. Get all the information you have, Mr. McKinney, so that Mr. Snell can be fully informed.
Yes, Your Honor.
All right.
Next is Jacqueline Thompson. Jacqueline Thompson.
How are you? Judge Jason McKinney on behalf of Jacqueline Thompson. Two case numbers, 25 CF 1764 and 1765. I have communicated with Mr. Snell to see if there was an offer that may get her out of jail today. There is not. We received the discovery today, and while I'm good at tap dancing, I'm not so good at reviewing it while I'm here in court. So I am immediately seeking to set depositions in both of these matters so that we can come to a resolution as quickly as we can. At this time, that's going to necessitate that I ask the court for a continuance until January 12th.
Well, at arraignment, the state announced that they were looking at 60 months DOC. Has the state changed their position at this time?
Not at this time. I believe that the reason that Mr. McKinney mentions the depositions is finding out exactly what each person is out, what they're lost from as a result of the theft, to figure out. There would have to be a way to pay the restitution before that offer would change.
Okay. All right. So we'll continue the case to 112 then, and get those depots. Realistically, though, is it 112 with the holidays and everything look like it's going to make it happen with the depots?
I've asked my office to coordinate with Mr. Snell's office to get those set. We have some dates in mid-December, so I'm trying to get that done in December. So I
Okay.
think that it's realistic.
All right. All right. All right. Very good.
Next is Tina Warrington.
Say again?
Tina Warrington.
Warrington. Warrington.
Judge, this is Ms. Tina Warrington before the court in 24 CF 2489. It is a 24 CF case, but there was time spent at Florida State Hospital in this matter. We did complete depositions, but since we saw Your Honor last, I'd like to come back on docket day, plea or continue. We are in active negotiation with Mr. Snell and are going to seek to potentially enter a plea to a lesser included on docket day if we can iron out some of the details.
All right. Very good. See you on docket day.
Next we have Kiera Wilson, W-I-L-S-O-N.
You doing all right? Yes, sir. This is Ms. Kiera Wilson before the court in 25 CF 1665. I was provided a score sheet in court today for Ms. Wilson that reflects a total of 18.9 sentencing points. I just wanted to make record of that. I have been in discussions with Mr. Snell. Mr. Snell, I believe that the offer that's current for Ms. Wilson is an 11-month, 29-day sentence followed by probation. Is that accurate?
That's correct.
By how much probation?
The restitution is about close to $2,000 to the sheriff's department, and so I'd want to give her time to pay it. And the the probation could early term as soon as upon payment of the restitution. So at least 24 months.
Because you would only get credit going back to the August 19th date. We're talking about April 29th.
All right.
Let me get the discovery and come talk to you.
So plea or continue on docket day, Mr. McKinney?
You want to talk about it on Friday? Yes. Yes, please.
Okay, we'll see you on Monday. Thank you.
Marcus Thompson. Chris Thompson, Thompson.
If we make some record for Mr. Marcus Thompson, he's here in a total of 4 case numbers, 25 CF 1196, and he's got 3 violations of probation. I have been in communication with Mr. Snell in trying to resolve these matters. I know Mr. Thompson is wishing to enter an agreement today. There are some score sheet matters that we need to go through before we can likely get to that position. And I understand that Mr. Thompson wants this thing put to rest, you know, as quickly as he can. But the position that we're in is, it would be the defense request to come back on docket day of plea or continue. That's Monday. I know that Mr. Thompson wants to do something today. But I would caution him that if he talks on the record, not to talk about facts of the case.
I would not do that. May I speak, Your Honor?
Yes, sir. Follow your lawyer's suggestion not to talk about the facts of the case.
Understood. The thing is, Your Honor, I mean, as we all know, I appreciate you all letting me go put my auntie to rest. However, it's a lot going on with my auntie right now. Me being incarcerated is not helping. I was a beneficiary of a lot that's going on, and cases have been closed dealing with help on my behalf, plus the insurance with the fire with the house. And there's so much going on, and I don't understand, like, if the state could, I'll take reinstatement or anything for me to get home. There's a lot going on, and I'm missing out on a lot of stuff that has to be done dealing with my aunt's death. And what I'm trying to understand, if the state has 1129 on the table, I'm willing to accept that, whatever come behind it, because I have to get home. I have a lot of stuff going on right now, and I'm still grieving my auntie's death. I appreciate you all letting me go to the furlough. I did what I was supposed to do. I'll come back on time. I don't understand why I'm still sitting in jail. I'm not gonna speak about the facts of the case. However, we all know what's going on, and I would like to speak with Mr. Snell to see if we can come up with something today. I can't, I'm grieving bad, and I'm sitting in this jail, and it's not helping me. So if he can come up with any, if it's $11.29 on the table, I'm willing to accept, but my time, sir, a program is not gonna help me. I'm not a resident of the state of Florida anymore. I'm leaving Florida. So if he could do anything to help me get up out of here, I would appreciate it. If it's reinstate my probation, whatever, I get my probation transferred to Georgia. I'm leaving Florida, but I have to handle some stuff for my auntie, and that's all I'm asking.
What can I do to assist Mr. McKinney at this point?
That's my thing is, I don't understand why put off for Monday what you can do today. I mean, nothing's gonna change between now and Monday. I think I have things to really take care of.
So he's going to score quite a bit, significantly an amount of prison, and Mr. McKinney is trying to negotiate something less for him, and that's the issue.
So what do I score up to?
That's what I want to find out.
Man, we're still holding me in jail, man. I mean,
Judge, if we could have a working score sheet going into Monday, then that's really what we need to put our heads together to try to fashion something that would be helpful for Mr. Thompson. Because my heart goes out to his situation, but I've got to have the documents in my hand to move forward and really move things around.
it's been ample time to do that, man. I understand.
Well,
Yeah, we approach.
yes.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
I'll see you on Friday regardless. And Judge, what I just told Mr. Thompson is that we're going to get our hands on the documents. I'm going to see him on Friday. We're going to talk about our options, and then we'll come back to court on Monday, plea or continue. That's about as quick as I think that we can move the needle at this point.
All right, so we'll set it for plea and continue on Monday.
Next will be Sean Tillman, Tillman. Tillman.
Work together, right?
Yes, Judge, this is Mr. Tillman. Mr. Tillman is here in 24 CF 2183, 24 CF 2443. Court's notes likely indicate that we were trying to get in Phoenix House. The state has indicated and told me today that they're not going to agree to that. That's what I just told Mr. Tillman right here in court. I'd like to come back on docket day, plea or continue. If the court will allow, I do believe that this is going to resolve short of a trial. But the defense well knows that both of these are 24 CF cases. If the court wishes to backstop, the defense is not going to have an issue with that. I fully anticipate that this is going to resolve on Monday.
Well, considering the change of plans, I won't push that based upon the age of the case. I mean, that's a significant sea change, and I'll give you some space.
Yes, Judge, thank you.
Next is Michael Walker, W-A-L-K-E-R. Walker.
Micah Walker?
Yes, Your Honor.
Okay.
All right, very good.
And Ms. Jaquith, Micah Walker is your case now, is that correct?
That's correct, Your Honor. Our office was appointed to 25 CF 1623. We do have a conflict, however, to assist with Mr. Walker getting his cases resolved, I had some administrative issues I wanted to address with the court. It does appear that Mr. Walker also has a case 25 CF 2065 that needs to be transferred down to the south end to run with the lower case number, and I just asked the court do that on the record today to expedite handling of that.
State object?
No, sir.
25 CF 2065 is transferred to this division.
And Judge,
Thank you, Your Honor.
The Office of
The
the
public-
Defender had filed a motion to withdraw in 25 CF 2065 in Division 6. I don't see it that an order has cleared.
The public defender is withdrawn from 2065. I guess, Ms. Jaquith, just to follow the protocols that I'm being told, I have to appoint you.
Yes, Your Honor, and there is also, we did file a motion to withdraw in the 25 CF 1623 case, so I would ask if the court would kind of disregard that order, I will add the second case number to that, an amended order, and provide that to the court so that we can get Mr. Walker, both of Mr. Walker's cases with the same attorney.
All right. And when do you think you might be able to get that done, Ms. Jaquith?
As soon as I'm through this with the court, I will file that, I will e-file the order in both case numbers, and I will get a subsequent motion filed in the 2065 case as well today.
Okay. And so what
But
we'll
I'll-
do is we'll leave you on for Monday. Your new counsel will be here, and that'll give a chance to close the loop by then, okay? If I just continue your case, then your new counsel might not be here, and you might not make that connection. So with your new counsel here Monday, that way you'll be able to meet them, okay?
Yes.
All right?
Your Honor, I did want to just, is the court appointing Mr. Nopes to these cases? Would
That was my
be-
intention. Has he got a conflict?
I don't believe he has a conflict, but I know that he is out of town the rest of this week. I just wanted to ensure he and one of the state attorneys may know better that he'll be back on Monday.
My understanding is he will be back on Monday. That was the announcement earlier today.
Fantastic. Then I will make sure the court has that order today so that he can be appointed and have that information before Monday.
All right, very good. All right, thank you very much. We'll see you Monday. Thank you, Ms. Jacob. Anything else for you this afternoon?
No, sir, and thank you for allowing me to appear by Zoom to handle that.
Absolutely, ma'am. Thank you.
Thank you.
Next we have John Wanamaker.
How are you? Did you have a chance to read this through? You good with it?
Good afternoon, Mr. Garrett.
Good afternoon, Your Honor.
After Mr. Waterman.
Need to sign that data right here. Judge, this is Mr. John Wanamaker before the court in 24 CF 2797. We have reached an agreement for Mr. Wanamaker. I would note that this is a 24 CF case. However, there were multiple evaluations through the pendency of this case. The latest one, I did have Mr. Wanamaker evaluated, and that did come back that he was competent to proceed. I wanted to make record that I have no issue with Mr. Wanamaker, and the communications that I've had with him as of late, I have no belief that he is incompetent to proceed at this time. We have reached an agreement for a plea as charged. The agreement calls for an adjudication of guilt. Count 1 is a third-degree felony, and that will be 36 months of probation. Counts 2 and 3 are misdemeanors. Those will be credit for time served. Special conditions will include that he attend and successfully complete the Phoenix House program Bars to Bet. He has been approved for that program. He must maintain gainful employment after Phoenix House. He must complete a mental health evaluation and any recommended treatment, maintain gainful employment. Oh, I believe I already said that. Follow all doctor's orders, take all medications as prescribed, have no drugs or alcohol, and be subject to random urinalysis and breath testing. Court costs are in the amount of $615 and $150 cost of defense. We will ask the court to waive all or a portion of the cost of supervision. This is a negotiated downward departure. No objections to the score sheet as provided. May I approach?
Granted. All right, raise your right hand for me, please, Mr. Wanamaker. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right. You heard what Mr. McKinney said?
Yes,
You
sir.
put your hand down. You heard what Mr. McKinney said, and you signed the written plea form.
Yes, sir.
All right. And how old are you, Mr. Wanamaker?
46,
And how much education do you have?
12th grade.
All right. You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what you read in the form what Mr. McKinney just told me?
Yes, sir.
All right. And you understand you're pleading no contest,
Yes, sir.
waiving your right to a trial by jury,
Yes, sir.
and you'll be adjudicated guilty. You're going to be on 36 months of probation, credit for time served in the misdemeanors. And the principal requirement in this is going to Phoenix House and successfully completing that, including their aftercare program.
So I still have a CRD to attend to.
Okay?
So would that come after?
He does have an F-4 hold. He is on conditional release, and this case violated that, so I don't know when F-4 will come and talk to him to have everything.
And I've had that discussion fully with my client. He understands that upon his release, that he has a bed at Phoenix House. That may not be tomorrow. That may be after the CRD.
Okay. All right, well, good. I'm glad that, so you're aware of that, and that's all part of this negotiation, what's
Yes, sir,
happening,
that's right.
okay? And so, and probation is aware of that too, so they'll massage that all out to be sure that it all happens correctly.
Yes, sir.
All right, and the same is with employment afterwards, and your evaluations and recommended treatment and continuing the treatment, including the evaluations from the doctor.
Yes,
And
sir.
those substances without a prescription and testing to confirm that.
Yes, sir.
Now, on the employment, if you choose to do something like training or go to school to better yourself for that employment, then I'll support you for that too. You just need to talk to probation. They'll explain that to you.
Yes, sir.
All right, with all of that, has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
And you satisfied with what he's done for you?
Yes, sir.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea.
Thank you, sir.
Thank you.
Do I get a copy of that, please?
Yes, you will. I'll send you a copy, and I'm going to reach out to them for the CRD again. To see if I can get a response. Got it. Thank you. Good luck.
All right. So, Mr. Garrett, you're another victim of the docket kerfuffle, right?
I believe so, Your Honor. We had court for Mr. Spicer on Monday, and my understanding is this case was continued to January 12th.
Right.
And there are two other felonies that he had. I have 25 CF 1612. The other two pending felonies, I believe, are with the public defender.
2662 and 2162 and 2163, correct?
Yes, Your Honor.
All right, and that's with you, Mr. Koch?
Judge, yes, that's correct.
All right.
And we are set tomorrow on those cases for pretrial detention.
All right.
Yes. Your Honor, may I just briefly touch on those pretrial detention, just a note?
Yes.
On the 25 CF 2162, 25 CF 2163, as of right now, the public defender's office is appointed. We do have a pending conflict. So I was going to seek a one-time continuance, I'm just saying for tomorrow. I just want to share that with Mr. Garrett. I don't know if he's going to come on to these cases, but I just want to make the court, Mr. Garrett, aware that I have a pending conflict.
All right.
Judge, may I just a brief moment?
Sure. I'm sorry, Mr. Garrett, with that noise on, I couldn't hear you. What were you saying?
Sorry. I was asking if he is set for a hearing tomorrow, what time would that be at?
That'd be 12:30. It's the pretrial detention. I think what Mr. Koch is saying is because of the conflict, he's going to move to withdraw. Judge Clark is covering that for me tomorrow because I will not be here. So you might want to address that now with the state. I'm not sure who's going to be covering those PTDs tomorrow. And the only reason I'm saying that is you might want to get it squared away now while we've got Mr. Garrett here and you're here and the state's here. If we're going to continue it, there's no reason to bring everybody back to continue the PTD.
No objection from the state.
You just want to... and when are the 2162 and 2163 set, Madam Clerk? Is there brand new cases?
Arraignment is December 11th, and pretrial is January 12th.
All right, so arraignments are set in the first cycle in December on those two cases. So the faster you can get that done, your withdrawal you can get done, the better. Mr. Garrett, do you anticipate coming in on the other two cases? Have you talked to your client about that?
I have not had a chance to discuss that with him yet. I will be in the very near future, however.
Your Honor.
Do you want me to leave this on, just redo what we did Monday and leave this on for Monday, all three cases, in case there's something else we need to do with the continuance of the PTDs tomorrow? But that way, I'll have him back in court on Monday. If there's anything we need to address, we can do that at that time. The defense can, the PD can get their motion to withdraw done. If there's a new appointment that needs to be done, we can get that all done at one time so we don't just pass it all for the full cycle. Does that make sense for everybody? Mr. Garrett?
Yes, Your Honor, I do have some motion hearings with Judge Wells at 8:30 a.m., but I'm sure I'd be back in time for court that morning.
Okay. All right. So, Madam Clerk, on this case, on the 1612, we're going to change the continuance to a POC on 11/17, and we're going to carry over the 25 CF 2162 and the 25 CF 2163 and set those on 11/17 as well. That way the PD can get their motions filed. Mr. Garrett can talk to his client about those two cases as well, anything he needs to do on that. And we won't pass it a full cycle. We'll be back in court Monday so that you have a chance to talk to whoever you need to about moving the cases forward. I guess with that confusion, I don't want to just leave the cases hanging for a full cycle at this point in time.
Are we continuing on the PTD tomorrow?
Yes, and the PTDs tomorrow are continued 1 week.
Yes,
All right, that will give you a chance, Mr. Garrett, if you pick the cases up to be prepared, and if you're not picking them up, then whoever's taking those two new cases can be prepared for the PTDs the next week.
Sounds good, Your Honor. Thank you. And Mr. Spicer, I'll get up to go see you either tomorrow or Friday, okay?
My word is nothing in this court. Her word surely got into this and we get in on it.
All right, so the motion, the pretrial detention motions tomorrow are continued. Instead of continuing your original case with Mr. Garrett a full cycle, we're resetting you Monday. So Mr. Garrett can get up to see you either tomorrow or Friday and be prepared to see if you're going to pick these two cases up. The PD is going to withdraw, but I'm setting your new cases on Monday. Ordinarily, they wouldn't be here until December the 11th, but I'm setting them on Monday to be sure we collapse the amount of time before you're back in court, okay?
You, sir,
I would not make any statements, no matter what. I know it. You said right wrong, let me tell you, do not make any statements, no matter what you say, you're not keeping on. I advise you, do not say anything about your cases.
And the reason for that is simple. We're making a recording. The state attorney's here. You can see he's got a pen ready. He's going to take notes about whatever you say. And if it's anything you say about the facts of the case, he'll use it against you in the prosecution.
Yeah, I would like to present what she has said about this case to the court.
It's almost always a bad choice for a defendant to speak in court against his lawyer's advice. Okay. Mr. Garrett can collect that information, and if he believes that that's something that can be presented, he can present it in a way that wouldn't impact your right to remain silent or incriminate yourself. It's just take your lawyer's advice on that, and we'll see you back on Monday, okay? All right? Thank you, Mr. Garrett.
Thank you, Your Honor.
All right.
Have a good day.
You too. Bye-bye.
Yes, we have Frankie Williams with Ms. Rebecca.
All right, was that clear, Madam Clerk? We're all squared away? Okay, all right.
We're still in the same spot. Go. This is Frankie Williams before the court in two case numbers, 25 CF 1735 and 25 CF 1737. Does Your Honor have 1736 off the docket?
I have all three, 35, 36, and 37. Has one of them been disposed?
1736 was consolidated when we went through pretrial detentions into one of the other case numbers, was my understanding.
Do you show that, Madam Clerk?
Yes.
And which was it consolidated into?
Into 1737. 1736 is into 1737.
Okay, all right. Thank you for pointing that out, Mr. McKeon.
Yes, Judge, and we have the two case numbers left for Mr. Williams. We do need to set depositions once we receive the discovery in 1735 and 1737. I've reviewed the lab report that was provided at the pretrial detention hearing, as well as the score sheet that was provided at the pretrial detention hearing. We would need the witness list to proceed forward in setting depositions. So I'm going to request a continuance from Mr. Williams in both of these case numbers until the 1/12 pretrial date. If there's anything that we need to do ahead of time, then I'll seek to file a motion in one of our December dates.
All right. State?
No objection, Your Honor.
So ordered.
Next will be Reese Vasquez, Mayor Wynn. Is this your, McKinney, with the assistance of Madam Mayor? Please.
Do you have any questions for me today? Jason McKinney, on behalf of Louis Vasquez, 25 CF 1720. We are set for pretrial today. We are going to be requesting a continuance until January 12th so that we may set depositions with the CAC. I met with Mr. Vasquez on the 5th of November and reviewed the information that we have currently. There is a current immigration hold, as the court makes notes. And an arraignment, I believe that there was an offer that was conveyed by the state.
And what is that offer?
It was substantial Department of Corrections time, followed by probation. So in speaking with Mr. Vasquez, he's indicated that he wishes for me to proceed forward with depositions.
All right. All right. Objections to the continuance?
No objection.
All right, matter will be continued to 1/12.
Correct. Correct. As soon as I get more information, I'll proceed again. Yes, sir. Have a good day. Thank you, Judge.
Is that all you have to make, Anthony Weaver? Okay. Weaver at the EAPR.
Judge, this is Mr. Anthony Weaver before the court. Mr. Weaver is here in 25 CF 823. Mr. Weaver does have a new misdemeanor charge. I don't believe that there is a case number on that yet.
Hold on, I don't show him on my, was that on the amendment, Madam Clerk?
I believe Sally added him from Monday to today, is that correct?
I believe he was on Monday's docket. When it originally ran, there was an arrest on 11/2 that changed his detention status.
Can you give me the status of other charges? Or is one misdemeanor?
Right now, you're charged with felony petty theft and misdemeanor resisting without violence.
But I came in on 11/2.
Yes, sir. You came in on 11/2, and they have arrested you for these two charges, but they don't even have a case number yet.
Still not.
So
And so so I've got the 823, and what's the other case?
Judge, it was an 11-2 arrest. It was a misdemeanor. I don't see.
So we don't have it yet.
So there is not a case number that's been assigned yet. But there was an order revoking bond at first appearance related to 25 CF 823. I'm anticipating that it's going to be a misdemeanor case based on the nature of the first appearance.
Disposition today?
Judge, I believe that if we were to move forward with a disposition today, and I've been provided a score sheet by the state attorney's office that reflects that Mr. Weaver scores Department of Corrections. In speaking with Mr. Weaver previously, I know that he wishes to contest all or a portion of this felony case. And he is very insistent upon getting the body camera footage, which would be part of the discovery. So I would like to get the discovery for Mr. Weaver so I could review that with him before proceeding forward.
Can I address the court?
We'll talk to your lawyer first. It's always a bad idea to talk in open court.
It's been ask your lawyer if you should talk about what you want to talk about before you talk out loud to me, okay? That's what I'm saying. Take your lawyer's advice. I don't care about
But we're talking about the
felony petty
20,
theft and resisting without violence. Sorry, sir.
it's the theft charge, right?
They go hand in hand if the officer was the same officer arresting within a certain time frame, and he acted illegally with excessive force and removed his body cam footage. He couldn't legally have made the arrest report on the petty theft.
Those are all facts that would, so you ready to go to trial? You want to go to trial? Is that what you're saying?
How about we have, what do they call that, motion to dismiss or evidentiary hearing when you come in and show the evidence? And you see.
Well, that's called a trial. Because the only way I could dismiss a case is very specific under the rules, or whether or not the facts support a crime was committed and you're the person that committed the crime. If you contest those facts, which it sounds what you're doing is contesting those facts, then the case goes to a trial. That's what happens.
I'm contesting the officer acting in an illegal manner and then removing the body cam footage and then another officer taking photos of another officer posing over me in handcuffs and chemicals. That's on the body cam. And there's no body cam footage of me being put in handcuffs. They removed that and used a security camera from a business to look down and sped it up so you wouldn't see the excessive force while he was on my back. I think that needs to be reviewed by the state and my attorney to see that this shouldn't proceed further. I'm not ready to throw this away.
Okay. Do you want to go to trial?
I'm not familiar with the court's rules, but I'd want the information packet for the jury to show what they can throw it out on when it comes to missing body cam footage or excessive force. Because it happened, they're saying from the time of that to the time I was placed in custody, a short span, which is considered one incident in the law, and if he acted illegally, he couldn't have made the arrest. It wouldn't be legal. You can't say I resisted without violence and you acted with excessive force. It's not legal to pose over somebody taking photos when they're in the camera, when they're in handcuffs. I'm saying nothing about the officer's conduct was legal in that manner, and that affects the whole case. And I don't know the right type of instructions or what to ask for the jury.
Judge, if the court wishes to leave this on the trial docket, the defense can get prepared on it. Since Mr. Weaver is in jail now, I know where he's at. I have the opportunity to meet with him on Friday, review the case in full with everything that we have received so far. But that's always going to defer to Mr. Weaver since it's his decision.
And I can make sure he has everything. I can do that before we go home. I'll make sure he has everything that I have by 7 o'clock tonight.
What discovery do you have, Mr. McKinney?
Judge, I have received what I believe is the paper discovery. I have not had the opportunity to do depositions in the matter. I have received a total of 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13. In upwards of, I would say, 30 pictures and videos. I have not had the opportunity to meet with Mr. Weaver since he's been arrested to go through each of these in full, but I believe that a copy was provided to him previous. And I believe that Mr. Weaver wishes to go through those videos with me.
Do you not agree that would be grounds for dismissal?
Which is something that we could proceed forward and do ahead of Monday when I see him on Friday. This is charged as a felony petty theft at Walmart, which is count 1, and resisting without violence, with OCSO being the arresting agency. That is the basis for count 2.
I don't know what else that I might have that he's missing. I'm going to ask Ms. Jones, my assistant, to resend everything. Looks like we provided the written and the e.com on July the 1st. And I can look to see if we've received something since then, but I don't know that we have. But my office will reach out.
And part of what Mr. Weaver has even told the court today is he believes that a portion of the video is missing based to body camera footage or the body cam being cut off. I have not been able to independently verify that or file any motions to compel or review with the state whether that is the case or not.
Do you want to announce POC or POT?
Do you want to go trial or not?
I don't feel like I'm being represented to the fullest right here. I'm going to be honest with you. It's been like 8 months. I've already brought this up when I saw you 2 months ago about the lack of body cam footage of me being properly detained. And then I saw the other footage, where the cop took a second phone out of his car and took a picture while another officer posed over me and another officer watched the traffic from the back road. That's on body cam. I don't know how you can act like that and then say you legally did an arrest report or an affidavit on anybody. Or is that justifiable? I just want to know. Can we, are you telling me it's in the ability to get a continuance, look at it, review it, and if you see that, is that an error? Is that not grounds for a dismissal?
Well,
important for the court to know that Mr. McKinney worked hard and secured a place for Mr. Weaver in a treatment facility. That's what's happened in the last 2 months, but he walked away from that and received new charges. So Mr. McKinney we're not just hanging out.
What question do you have?
Not working his case. So he's done a good job for him, and that needs to be said.
So I guess the question is, seems like the defendant's really upset about his arrest on the resisting. So maybe we'll just bifurcate the case and we'll try the resisting case separately after he has the chance to talk to Mr. McKinney and go over all the body cam or missing body cam and whatever. And we'll just try the petty theft, felony petty theft. I still have a hard time with that.
Yes, sir.
What are we doing?
The state would be fine with that.
We doing time, sir,
We're talking about.
on this? And then what you offered last time?
That was last time. The score sheet that I've got now, because we've got the discovery, it shows 22.5 months.
So, plea or continue or plea or trial on Monday?
We doing time, sir?
I don't have an offer for time served.
Well, then we're going back for continuance.
Do you want to continue it so that you can review
I
the
don't,
case with me?
yes, I need to review the case. I need the discovery to come and we can fully review it.
What Mr. Weaver has just told me is that he wishes for me to ask for a continuance to review his case fully with him at the jail.
All right. It'll be continued.
That's something that will be ready on the next docket, Judge.
All right, and once again, you've heard the state, they're willing to bifurcate. If you believe there's more details that you need to dig into for the resisting, then I'm willing to do that as well to expedite the case for the disposition.
Yes, Your Honor.
And I know that presents more technical issues and challenges for you in reviewing the discovery with your client. And if that's the case, then we'll do it that way to be sure you've got the adequate time so that you can zealously represent your client, as I know you always do.
Yes, Judge.
All
And
right, thank you now.
I will still meet with Mr. Weaver as quickly as possible to review the case in full. Thank you.
Thank you, Your Honor.
Madam Clerk, do we know when we're going to get a case number on the misdemeanor by chance?
No.
Judge, that was And Judge, that was Monday, or was that a continuance until the 12th?
That was the full continuance is what I
Yes, sir.
understood you.
That was my understanding as well. I wanted to make sure on the record. Thank you.
This is Joyce Richmond.
Judge, this is Ms. Joyce Richmond, 24 CF 416.
416.
If I may have a brief moment for a signature.
You may.
Thank you, Judge. This will be a no contest plea this afternoon. Count 1 is going to be no prost, leaving count 2 a misdemeanor. That will be adjudication of guilt, 60 days in the Okaloosa County Jail with credit for time served, court costs of $270, defense cost of $150. There is a prisoner transport fee to the Okaloosa County Sheriff's Department in the amount of $937.04. My client does live in Ohio, and she will be getting released today, Your Honor. And she's aware that if she stays in Florida, to check in to the sheriff's office to notify them of the sex offender for temporary residence. But her intention is to move, or go back home in Ohio. And if we can get 24 months to pay that, Your Honor. And if I may approach with the signed plea form.
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
Put your hand down. You heard what Mr. Koch said, and you signed the written plea form?
Yes.
Do you understand you're pleading no contest to the misdemeanor in this case?
Yes.
You'll be adjudicated guilty, serve 60 days county jail, credit for time served, and have the fees and costs that you have to pay.
Yes, sir.
And how much time did you request, Mr. Koch?
24 months, Judge.
Do you think you'll be able to get it done in 24 months?
Yes.
Okay.
And there is a correction on the cost.
Okay.
It's driving, so it'd be 300.
300?
300.
Thank you, Madam Clerk.
All right.
So it's going to be 300.
24 months to pay, including the cost of transportation. Mr. Koch answered all your questions. You satisfied what he's done for you?
Yes.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Okay.
Remember, check in if you stay down here. Yes, Ms. Richard. Thank you, Judge.
Next will be Jessica Rogers, R-O-G-E-R-S. Rogers.
Judge, this is Ms. Jessica Rogers, 25 CF 1640. Yes, Your Honor. I originally had my client, and we pled out on September 11th. This is for a violation of probation. I'm asking to be appointed on that violation of probation, Judge.
May I have that case number, please? I don't have it.
25 CF 1640.
Thank you.
I don't have that either, Madam Clerk, right? So it's only the VOP and that just basically got left behind? Is that what happened?
Judge, this is, she picked up a new law violation misdemeanor, went through first appearance, revoked the bond in our case. I was never appointed to the VOP. I'm not quite sure how it ended up on this docket. But
This is not about you, ma'am. We're having problems with the docket, so I'm sorry I'm laughing, but it's been a running joke about who's on the docket, so it's not about you. I apologize. All right, give me the full case number again, please.
25 CF 1640.
And I just see the warrant issued, so we had not only it looks like and I'm just making a record so it's clear. Looks like the revocation happened on 10/28. That was followed up by the VOP and report on 11/7. I don't see that warrant has been served. Do you see that it has been served? Or do you have it for service?
No, I just showed it's been issued, and it was sent actually today.
Okay.
To the sheriff's office.
So the warrant is outstanding and hasn't been served yet. And the reason I make that clear is be sure there's no confusion about that. So what we'll do then, Madam Clerk, is we're going to treat this as if it were a VOP arraignment today. All right? And I'll appoint the public defender to represent the defendant. Do you wish to enter a plea?
Judge, I'll be entering a denial, and if I can request this case be put on Monday's docket, so now that I can open up Ms. Rogers' file, I can talk to the state, maybe we can come to an offer for Monday.
That would be wonderful. I was hoping for reinstatement.
Yeah, no, I don't want to make any statements about the case, but I'm going to request the court if we can keep you on Monday's docket, or put you on Monday's docket.
All right, thank you.
All right, so we'll put it on for then, and hopefully by then, we can get that served. If not, we'll serve her in open court on Monday, because, and Mr. Koch will explain, I don't want that warrant to be outstanding if we resolve it Monday, and then you have a warrant floating out there that gets served.
It's a whole mess.
Yes, it is. No, it's okay. Yes, we know. And I'm trying to avoid that because that's not fair.
All right.
All right, so we'll see you on Monday, and Mr. Koch will chat with the state and hopefully get that squared away.
Okay, thank you.
All right, thank you. Good day.
I would like reinstatement.
Yes, ma'am.
Okay, thank you, Thomas.
You're welcome.
All right, now have one today.
Oh, I will.
Hey, Rita Rogers?
I will remind you that. Judge, this is Ms. Rita Rogers, 25 CF 1536. That was 25 CF 1536. If I may have a brief moment for a signature.
Yes.
Judge. Yeah. All right, thank you, Judge.
You're welcome.
Judge, my client will be entering no contest plea this afternoon. It's going to be a no pros on count 2. The remaining counts, counts 1, 3, and 4. Adjudication of guilt, 135 days, Okaloosa County Jail. Credit for all time served. This will be $615 in court costs, $150 in defense costs. All counts to run concurrent. If I may approach with a signed plea form, and Mr. Snell will follow this with a score sheet.
But you do agree, Mr. Snell, that this is this a departure?
I believe it will be, Your Honor.
All right, uncoerced, negotiated plea agreement, all right?
Yes, sir.
All right. And counts 1, 3, and 4. Trespass. So only count 1 is a felony, correct?
That's correct, Judge.
All right. Raise your right hand, please. You swear affirm, testify truthfully in this matter under penalties of perjury.
I do.
All right, you can put your hand down. You heard what Mr. Koch said, you signed the written plea form?
Yes.
How old are you?
I am 52.
How much education do you have?
Some college.
You able to read and understand the plea form?
Yes.
Did you do that before you signed it?
Yes.
And is what you read what he said?
Yes.
You understand you're pleading no contest?
Yes.
That tells me you think the state's got the evidence to prove your guilt and you're not going to contest that.
Right.
Do you understand by doing this, you're waiving your right to a trial by jury where the state would have to present that evidence to the jury to prove your guilt?
Correct.
All right. In this case, you'll be adjudicated guilty, serve the 135 days county jail credit for time served with the fees and the costs. And are those correct, Madam Clerk?
Yes, Your Honor.
And how much time do you need to get those paid once you're out?
How long can I get? I don't know.
We can ask for a year to pay.
Up to a year, yeah, at least.
Okay, I'll give you a year to pay.
Bless
All right. Mr. Koch answered all your questions about the plea and how it affects you?
Except for how much time I have to continue, do we know that? Or?
Judge, and I can answer that. I can't guarantee, and this court can't guarantee any gain time, but in the plea form, we can say all time served, and the calculations is around 110 as of today. So I can't guarantee any gain time, but, so I can't
I've been good, no trouble, since 110 days.
Right. So that's the best we can do for you. All right. So you get the 110 that you've served, plus whatever gain time you have, towards 135.
Okay.
Okay. All right, with that, the court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you.
Next will be Jennifer Sexton.
Judge, this is Ms. Jennifer Sexton. 3 cases, 24 CF 125, 24 CF 1029, and 25 CF 1858. If I may have a brief moment.
You may.
Judge, currently in front of me, I do have a global plea offer for 12.1, Department of Corrections, credit for time served. Mr. Snell provided me that this morning. I'm asking if we can keep my client on Monday's docket for plea or continuance, all 3 cases, and if we can keep this offer open.
All right, what are the other case numbers? Because I only have the 1858. What are the other 2 cases?
Yes, Your Honor. 24 CF 125, and then 24 CF 1029.
Okay. All right, so we'll leave them on plea or continue on Monday.
Thank you, Judge.
All right.
Thank you.
Keep that with you.
Okay, thanks so much.
All right, you're welcome.
George Sharp, SHARPE.
Your Honor, this is Mr. Sharp. He's here on 4 cases, 25 CF 1006, 25 CF 1023, 25 CF 1025, 25 CF 1217, Your Honor. Judge, I'm asking for a continuance to the January 12th date. Currently, all 4 cases, I got 13 depositions scheduled for December 9th. So I'm seeking the continuance to the January 12th date.
State?
No objection.
All right, matters continued. Thank you.
Okay? Yeah.
Yeah, 25 CF 1217 is the only case that I show that it's pro se. The TV is not.
You're appointed on 25 CF 1217.
1217?
Right.
Yes, Judge. Okay, excellent.
Next we have Luis Rivera Soto.
Mr. Vera Soto, Judge, I have 2 case numbers, 25 CF 1147, 25 CF 1400, Your Honor.
Yes, sir.
Judge, seeking a continuance to that January 12th. We have scheduling depositions on both cases. In the 1147, that criminal mischief case, Mr. Snell is going to provide me with discovery on that case, Judge. And currently, I know before, if we gave the offer, it was 8 years DOC, followed by the 7 years sex offender probation, and guidelines, 95.4 months, Judge.
And the offer, I say again, the offer amount?
I'm sorry, Judge, it's 8 years Department of Corrections, which will be followed by 7 years of the sex offender probation.
Okay. That's the current offer.
That's the current offer.
Okay. And so full continuance?
Yes, Judge.
State?
No objection.
112.
Yes, Your Honor. Thank you.
Thank you, sir. Next will be Nathaniel Pate, PhD.
Judge, this is Mr. Nathaniel Pate, 25 CF 685. If I may have just a brief moment.
Yes, sir.
Thank you, Judge. Thank you, Judge. If we can set this case for Monday, it'll be plea or trial. So plea or trial. And, excuse me for a second. The current offer, Your Honor, is adjudication of guilt, the 16.73 months DOC, and that is the guidelines, 16.73 months DOC. Of course, credit for time served, the 515 court costs, 150 defense costs. There's a cost investigation of $290.73 to Niceville PD, and reserve restitution for 90 days, Your Honor. That's the current offer on the table. And my client is aware that there are no negotiated pleas after docket day Monday.
All right, and if we try the case, how much time is it going to take to try?
1 day, Your Honor.
You agree?
She'd agree, standard 1 day.
Okay. Yes, sir.
How many jurors?
Standard number, Judge.
All right. All right, we'll see you Monday.
Excellent. Thank you, Judge. Yep, you're welcome.
This will be William Pearson.
Judge, this is Mr. William Pearson, 25 CF 1781. Your Honor. Currently, Your Honor, the offer is the guidelines, which is 21.53 months, Department of Corrections. And as charged, there is an exposure of 60 years. Judge, this is the offense date per the information was March 8th of 2013. As of right now, I repeat, I do not have a legal basis to file a statute of limitations motion to dismiss. Speaking with my client yesterday, if facts change, we can always file that motion. I am seeking a continuance. This is the first time in front of you for pretrial conference to set depositions, do additional research on the statute of limitations. This is an older case. I have not received videos yet. I don't know if there are videos, but I just want to state I do not have any videos as of right now. I am seeking a continuance to January 12th, but Mr. Pearson, I want to make sure you have no objections, because if you want trial, we could set it for Monday, but I am seeking a continuance for those reasons.
Continuance is fine.
So we are seeking continuance to that January 12th, Judge.
No objection from the state.
Yeah. Okay, I'll talk later. Thank you. Okay.
All right, so it'll be continued to 1/12.
Yes, Judge.
What was the date?
1/12.
Next will be Lloyd Poole, Poole.
Judge, this is Mr. Poole in 24 CF 434, Your Honor. Judge, this was a case we were waiting on an outstanding evaluation report from Dr. McDonald. There was one provided last night. I do have a copy available for the court.
All right.
If I may approach.
Yes, sir.
Okay, just want to make sure you're on the same page, yeah. I'm sorry.
Does the state accept the report?
Yes, sir.
Defense intend to do anything additional regarding the report?
Negative, Judge.
All right, I'll consider this a competency hearing, and the court will determine based upon the stipulation and the admission of the report. Have you filed that?
Not yet, Judge, not in order.
No, the report, has it been filed?
I believe so, but I'll have to check, because I know it was last night.
Okay. The court does find that the defendant lacks the capacity to proceed and will commit the defendant to the care of the Department of Children and Families for restoration.
Okay, Judge.
All right?
What does that mean?
Just follow the deputy.
What does that mean?
Just follow the deputy.
Ernest Powell. Ernest Lee Powell, Jr.
Judge, Mr. Powell has 2 cases on today's docket, 24 CF 2864 and 25 CF 1136. My client also has a new law violation that is on tomorrow's docket as well, Your Honor, if I could provide that case number.
Yes, sir.
It's 25 CF 1985.
Okay.
Judge,
Is that on for arraignment?
tomorrow, yes, Judge.
Okay. Has information been filed?
Yes, Judge.
Okay. Do we want to treat this as your arraignment today?
Yes, Your Honor.
Okay.
I was going to enter not guilty and waive formal reading on the 25 CF 1985.
So, done.
Thank you, Your Honor. Now, with the 2 remaining cases, Your Honor, if we can set them for docket day, this is plea or trial. And currently, with that new case, Mr. Gomez provided a new score sheet and reflected a global. So this is to include all 3 cases of 65.33 months Department of Corrections. That is the current offer. And all 3 cases has an exposure of 60 years.
Judge, the state would ask the court to set the 2024 CF 2864 case for trial. Or that's the case that the state would want to try first.
And if we try that case, how much time is it going to take to try?
I expect 2 days to be safe.
How many jurors?
30, just to be safe. 30.
Yeah, that's fleeing and looting and
Possession.
30.
30, Judge, 30, defense and state.
All right. So we'll see you on Monday, and you've talked to your client about, after docket day, what the situation is?
Yes, Your Honor, after Monday, there's no negotiated pleas, it's only a plea to the bench. But we still have an opportunity for a plea agreement Monday, which we've also discussed.
Okay. All right, see you Monday. Thank you.
It's Monday. Oh, yes, I'll see you privately. I'll bring it in. I'll see you privately.
Just the 2 cases, correct, or all 3 of them? Okay.
Just Monday on those 2 cases.
Next is Brian Quinones.
And can we remove him from the, oh, thank you, for tomorrow. Judge, this is Mr. Brian Quinones, 24 CF 2213.
Yes, sir, go ahead.
Excellent. Your Honor, I'm seeking, actually, can I have a brief moment, Your Honor?
Yes, sir.
Just enough. Judge. Judge, we are seeking a continuance to the 112. I have two depositions set for 12/17. This is going to be the FDLE, gunshot residue, and forensics. Also, we had subpoenaed FedEx in Defuniak for footage of a separate vehicle, a FedEx vehicle, but not my client's. And they responded to that subpoena, and I got an update this morning. It's with a Miss Stacy Stevens at FedEx. I haven't confirmed or received that video, but that's another addition for that continuance.
State?
No objection.
All right, it'll be continued to 112.
Yes. All right. Yes, Brian.
Next will be Cheyenne Ramey.
Mr. Ramey in 25 CF 1649. And if I could have just a brief moment, Judge. Judge, I'm seeking to put my client on Monday's docket for plea or continuance. Mr. Snell is going to provide me some discovery and an offer, and I want that opportunity for my client on Monday.
So ordered.
Thank you, Judge. See you Monday.
We're going to take a comfort break at this time for about
Yes, sir.
5 minutes, okay? 5 minutes.
Counting down. All rise.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take 1. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays, 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you.
Then I've done it twice now because the first one was apparently stricken. So I didn't know if you were aware of that.
Well, let me get there. Okay, give me just a chance, okay?
All right.
I think you filed that on 10/27, is that right?
That was the second one, correct.
Oh.
The first one was on the 6th, and I received a receipt of it, and then the notification I got from it was dated on the same date. which makes no sense.
Okay, all right. Well, raise your right hand. Do you swear or affirm testify truthfully in this matter under penalties of perjury?
Yes, absolutely.
All right, well, tell me what's going on with your lawyer and what it is you want me to do about it.
Well, on August 23rd, 23, let me see. I have everything written down. So we're having the hearing now, then, is what you're saying, correct?
Yes, sir.
I was not given the opportunity to be heard as required by established law, resulting in the court departing from the essential requirements of law, resulting in irreparable harm. Okaloosa versus State. Mr. Koch, from the time of his appointment, only visited me one time before being sent to Florida State Hospital. Mr. Koch only revealed the nature of the charges that I was facing. No defense strategy was ever discussed with myself during the first year I was lodged in the Okaloosa County Jail. He has not made any independent investigation during that 1 year period, only continued defendant's case approximately 5 times. I have requested depositions to be taken, which they are finally now done, out of the listed state witnesses some 2 years ago. On about June 23, Mr. Koch suggested I be evaluated by a clinical psychologist. I did express to him that I did not need the competency evaluation in Chattahoochee, which I've obviously proven competent from, which I did not suffer any mental illnesses, nor have I been prescribed any medication, obviously. And the hospital evaluation did not reveal any mental or physical deficiencies. Sorry, I'm reading everything. I did get a partial discovery now after 2 years, which includes information on some person not connected to the case. I have requested a copy of any death certificate on file and an autopsy report. Those have not been provided by him either. Given the undeniable facts that Mr. Koch has not made any effort to independently investigate, conduct depositions, discuss any defense strategy, answer any of my correspondence, make any personal visits, or keep myself informed as to how Mr. Koch intends to proceed, clearly speaks volumes as to the lack of Mr. Koch's desire to represent myself. I believe Mr. Koch does not have his best interest at heart and that there is irreconcilable differences and a conflict of interest between himself and myself. If you'd like, I could give you everything I have written.
No, sir, that's not necessary.
Sorry.
Mr. Koch, do you wish to offer anything to the court?
Just briefly, Judge. And I'm just going to stay till once Mr. Razor returns to Florida State Hospital, provided all paper discovery on 9/9 this year. Our discussions, I did set those depositions, completed 7 of them, spoke with the state attorney. She provided me some additional discovery. As I stated, 109 photographs, 44 videos. Currently, this is a guideline sentence, or excuse me, Judge. This is the guidelines are 196.5 months, DOC, maximum exposure of 35 years. I'm seeking the continuance of the 112 route to go over that, complete depositions, and talk about further depositions.
And as you know, Mr. Razor, I didn't take over supervision in this case until January of this year. Before that, it was Judge Brown maintaining the supervision of the case. This reason I was taking as much time as necessary to review the progress docket. And Judge Brown made the determination, looks like on July of 24 that you were not able to proceed and entered an order to that effect, and that was based upon the report that was done by the doctor, and I believe that date was done originally on 5/28 of 24, and that subsequent to that, after being at FSA for a period of time, they made the determination that you had been restored to competency and returned you here. During that period of time, all the proceedings would have been suspended until you were returned here. And that's what I was just reviewing, the progress docket. And once that occurred, then the case has been proceeding, and the appropriate, appears the discovery exhibits and depositions and have been proceeding forward, and during the pendency of, during the time you were at FSA, it would have been inappropriate for anything to occur because you would not have been present and had the ability to participate. So given that and given what's been presented, I don't believe I can make the finding that Mr. Koch's representation of you falls below the standard that is required by the case law, such that I could discharge him and appoint substitute counsel at the state's expense. So your request is denied. Do you wish to continue the case?
I am requesting that January 12th for a continuance, Judge.
All right, so ordered.
This will be Kevin Riley, R-I-L-E-Y. Judge, before we get to that individual, we'll get somebody out of the audience.
Yes.
Judge, she has been here for a good portion. Her name is Cody Owens, I believe represented by Mr. Nose.
Yes.
She is one of the individuals that was placed on this docket while she was incarcerated, made bond, and had the notice for today.
Right, and I think that on 112, I think I already signed an order continuing the case. That, I think, was some of the confusion.
Yes, sir. I just didn't want to
No,
I was on the
no, I
docket, because I
appreciate
checked the
that.
docket when I went to when I first got here, so I just didn't
Yeah.
want to miss it, so.
Yeah, and, but it's already been continued to 112.
Okay.
Get in touch with Mr. Nope so that he can have access to you to help resolve your case.
All right, thank you, sir.
But thank you for being here, and
Yes,
thank
sir.
you, Mr. McKinney, for being a friend of the court.
Thank you. Mr. Kevin Riley in 25 CF 1411, Your Honor.
Yes, sir.
Thank you, Judge. This was, we had a deposition scheduled for the alleged victim. Failed to show, but he was incarcerated, so we know where he is. I'm asking to set this for plea or continuance on Monday. Speaking with Mr. Snell, we could possibly resolve this without resetting that deposition.
No objection. Yes, sir.
All right. I'll see you on Monday.
Thank you, Judge. I'll see you back here Monday.
Next will be Judson Roberts.
This is Mr. Roberts in 24 CF 2225, Judge.
Yes, sir.
Judge, yes. This was, just to update the court, we had a outstanding order signed by you for Dr. Benson to evaluate my client. Fortunately, my client failed to appear for a pretrial, now is in custody. So my office is coordinating for Dr. Benson to come out to the jail to conduct that evaluation. So I'm seeking a continuance to the 112.
State?
No objection.
So ordered.
And once that evaluation is conducted, Your Honor, if it's before that 112, can I put my client on the docket to?
Absolutely.
Okay.
As soon as that's done and ready to go, you set it.
Thank you, Your Honor.
All right, very good. Thank you.
Next will be Ronald Roberts.
This is Ronald Roberts. Your Honor, I have two cases, 25 CF 822, 25 CF 1606.
Yes, sir, go ahead.
Judge, in that 25 CF 822, I've received discovery, depositions are being set. In that 25 CF 1606, Mr. Snell is going to send me over discovery and a global plea offer. I'm asking to set both these cases for Monday, plea or continuance.
All right. Clear, continue on 11/17.
Thank you, Judge. You'll be brought back. I got you, yeah. I like sound good on that stuff. We're back here Monday. Yep.
Jeffrey Schreiner.
Yes. This is Mr. Jeff Schreiner in 25 CF 1689, Your Honor. If I may have a brief moment for a signature.
Yes, sir.
Judge, my client will be entering a no contest plea this afternoon. Count one's going to be the lesser included offense, petty theft misdemeanor. That's a Florida State Statute 812.014, subsection 2, subsection F Foxtrot. The terms will be adjudication of guilt, 90 days Okaloosa County Jail with credit for time served, 270 court costs, 150 in defense costs, No return to the Home Depot located at 414 B Bravo, Mary Esther Boulevard Northwest. That's Fort Walton Beach, Florida, 32548. And there's restitution in the amount of $98.91 to that Home Depot. I did put that restitution address on this plea form, and we are asking for 180 days to pay off that restitution. If I may approach with a signed plea form.
Granted. All right, raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, you can put your hand down. You heard what Mr. Koch said, and you signed the written plea form.
Yes, Your Honor.
You understand you're pleading no contest or lesser included offense,
I do.
waiving your right to a trial by jury.
Yes, Your Honor.
You'll be adjudicated guilty, sentenced to 90 days county jail, credit for time served, with the fees and costs and the restitution.
Correct.
And Madam Clerk, are the fees and costs correct?
Yes, Your Honor.
All right. How much time do you think you'll need to get those things paid after you're released?
Jeff?
180 days.
It's 180 for the restitution. That was part of the agreement with the state attorney's office, Your Honor. If my client get a full year to pay those court costs. Yes.
All right, a year to pay.
Thank you, Judge.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Your Honor.
You're welcome.
Judge, this is Clarence Walton before the court in 24 CF 1931.
$19.31.
Correct.
24/1931.
Correct.
Give me just a second. I don't have that on my docket. All right, go ahead, Mr. McKinney.
Judge, procedurally, I'm going to be requesting a continuance until January 12th. I am going to be filing a motion related to Mr. Walton's bond. The court had signed an order revoking bond on August 8th. And I'd like the opportunity to file a bond motion for Mr. Walton to be heard next week on the 20th if the motion is filed properly. In addition to that, I would like to briefly approach with the state.
Yes, sir.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Where I
All right,
Pressure.
we'll continue the case. If you get your bond motion filed timely, we'll set it on 11/20.
Yes, sir, we'll do so.
All right, thank you.
Judge, may I call Joel Walls?
Walls.
Mr. Walls was sent over for Monday for today for entry of a plea. He is present. Mr. Walls would be withdrawing his previously entered plea of not guilty and entered a plea of no contest as charged in 25 CF 1126. The agreement with the state is for an adjudication of guilt, 30 days in the Okaloosa County Jail with credit for all time served, $615 in court costs, $150 cost of defense. We would ask the court for a period of time upon his release from jail to pay off the financials. No objection to the score sheet, which reflects 29.4 points. May I approach?
Granted. All right, Mr. Wells, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. You heard what Mr. McKinney said. You signed the written plea form.
Yes, sir.
How old are you?
42.
How much education do you have?
GED.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And does the plea form contain the terms and conditions Mr. McKinney announced?
Yes, sir.
Do you understand you're pleading no contest to the charges announced?
Yes, sir.
That tells me you believe the state could prove your guilt and you're not going to contest that.
Yes, sir.
And I understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
In this case, you'll be adjudicated guilty, be sentenced to 30 days county jail credit for time served with the fees and costs that were announced.
Yes, sir.
How much time do you think you need to get to pay those after you release?
About 6 months.
All right, 6 months to pay. Mr. McKinney answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied with how he's represented you?
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and will accept the plea with the adjudication. If you'll step over this way, please.
Judge, there is another matter. It is actually on Monday's court date, but we can gain some ground if I may announce.
Yes, sir.
It's a Brent Whitner, 25 CF 629. We had passed it over to Monday for a pay and dismiss.
Right.
And we did get the information that we needed. If I may announce for the record, Madam Clerk. The restitution would be ordered in the amount of $840.15 to Emerald Coast Cars at 604 Choctaw Drive, Destin, Florida, 32541. And I did provide that for Madam Clerk, but I wanted to make the announcement for the record.
All right, so we leave it on for Monday for that to take place? Is that what we're doing?
Yes, Judge.
Okay.
But now he can actually gain some ground if he goes to try to do it.
All right, very good.
All the information is in the computer.
All right. So, Madam Clerk, you got anybody left?
Yes.
Yes?
Yes.
I have cases that are.
Would you like to take some more?
Case number.
Case number 21 CF 2774, Stephen Hardwick.
2774.
Yes.
Hardwick, Stephen.
Mr. Hardwick entered a plea last week in front of Judge Clark, who's covering the Judge Swan here.
Okay.
I forget what day that was, because it was last week.
I needed that at this time of the afternoon. Thank you, Mr. McKinney.
Second one, I have Larry Ivy.
Yes, Mr. Ivy, Your Honor. I'm sorry, go ahead.
2173, correct?
Yes, sir.
Your Honor, I'm asked to set this 112. Hopefully it will be resolved before then. This is the gentleman who is in DOC, but he's paralyzed.
Right, he needs special transport, and we can't seem to figure
Yes, Your
out
Honor.
how to do that.
I did have a DOC call with him last week on resolving this case. I think we're gonna be able to come up with a concurrent time. It's just a matter of getting paperwork to him to get signed, so we can get it back here and set him for a hearing.